The whole object of this is for all parties involved to understand we have a serious problem going on within the U.S. Department of Transportation and the cabal of people on K Street and insurance companies and cities and counties that have a financial interest in the predatory practices going on around the country with no oversight. What happened here is after the 55-mile-an-hour speed limit, the Federal Highway Administration, in particular NHTSA, went on to create a system of propaganda that lied to the public the entire existence. The uniformity here is extremely important because think of it this way. There's 80,000 entities or more that have police powers over travel as you go from imaginary line to imaginary line. And there's over 4 million, almost 5 million miles of travel corridors now that are affected by the travel law. This law affects every entity, public or private, that's open to public travel. Doesn't care. Doesn't care if it's a territory, doesn't care if it's a government base, it doesn't care if it's a highway, a county, an Indian reservation. They're all subject to the same federal law. So therefore, when a traffic engineer uses the traffic control device, it must comply with all the federal standards, which mean it's been vetted, the fact that it's efficient, effective, and works in the application. And they've done double-blind tests to make sure that it works. But in a traffic control device, if it's a regulatory device, it must apply to equal protection and due process. You can't have an invented crime on a traffic control device in a federal system with 80,000 entities applying police powers and have a different standard every time you cross a line. You can't have a different expectation, and it can't be invented crimes. So therefore, every single thing that a city does when they place a sign is under the nexus of the federal Constitution, federal law. The same thing goes for the vehicle codes and state law or city codes. And then again, the judiciary is also under the federal standards because anything they apply under federal standards must look back to the rights contained in the Uniform Vehicle Code and the adjudication standard that's to be applied in this application. A city cannot put a regulatory device up, a speed limit sign or anything else, a stop sign, without having a standard applied as both to the expectation and standard where it's applied, but the expectation of motor applying to it. So therefore it can't be an invented value. If a city wants to do something using a traffic control device, they must go to the engineering department and ask them what they want done. The engineering department can come back with solutions. If the city doesn't like the solution, they can go back to the engineering department and say what other solutions are available. But in no case can they tell the engineer to do something that's not contained within the federal regulations. So all these cities going up and saying, I want a 25-mile speed limit or I want speed cameras on this road, unless the underlying predicates have been accomplished and done according to the national standards, it's not legal on its face. So every time you see a city council saying, I want to do this and I want to do that, they don't have the authority to do it under federal law. They have the authority to do it if they follow the federal regulations onto its application, but they don't have the authority to argue or to place it absent meeting those requirements. And when it comes to the courts not only have to look to state law, but state law must be in substantial conformance to all requirements on equal protection, fines, standards applied, due process to federal law, and it can't be disparate from that. The wording might be slightly different, but the expectations have to be in conformance with the federal rights in due process and equal protection.